Welcome to this edition of Between Two FARS. I'm Warnicki Miller, and I am delighted that I'm being joined today by two of my favorite procurement attorneys. Both Robert Tepfer and Michael Mark are here today. And before I introduce them further, I just want to share a quick story with you. I had a chance last July to go to a training with both of these gentlemen, and I sat right behind them. And the entire time I felt like I was in the Muppet Show, because these two gentlemen, they knew a bad act when it came on stage. And anytime we had a presenter come up who said something that wasn't quite right, these two were on it and were correcting him and were letting the presenter know what and who's who. So I want to introduce you to NASA's very own Statler and Wardorf. We have with us today Michael Mark and Robert Tepfer. How are you guys doing today?
Doing well.
I'm doing great.
I know you guys have a long history together. Could you quickly tell me how you guys met?
I was in the LLM program. That's the Master's in Law program at George Washington University in 1981. And there was this kid, Michael Mark, who had just joined the Air Force recently. I'd been there for like 5-6 years. And he was taking a course at George Washington University at the same time that I was. He was taking it on his own. And we ultimately either sat together or rode back and forth together. And then subsequently, we went to all sorts of programs together for the 22 years I was in the Air Force and then in NASA. So we've known each other for a long time.
Yeah, I was the new attorney at the Air Force Office of Scientific Research. I'd arrived in 1980, and they made me the patents officer. I'm not a patent attorney, and I knew nothing about government contract law, so I was desperate to learn as much as I could, as quickly as I could, and signed up for the course Tuition Assistance. And Bob was one of the Air Force LLMers in there. It was funny. They used to park at the Kennedy Center, and it was a night course, and I would drive from Bolling Air Force Base, and I could get parking right by the school. So I would haul them to the Kennedy Center afterwards. So we got to know each other in a lot of conferences. Bob and I overlapped for a few months in his last assignment at Wright Pat. And then when I was retiring, I let him know that I was going to be retiring from the Air Force. And he said, well, give me your resume. And little did I know, but he shopped it. And one thing led to another, and I got hired at Langley. So I think I owe my NASA career to Bob as well.
Yeah, I wouldn't go that far. We both got LLMs. Michael's is with highest honors. We both ended up in therapy since we did a thesis for Ralph Nash.
Yep.
Well, I am so glad to have you guys together to talk about one of my favorite contract subjects, litigation. And I'm hoping this will be the first of many episodes with you guys together where we can talk about two of our most common types of contract litigation, the litigation in front of the GAO and the litigation that we have sometimes in front of the Armed Services Board of Contract Appeals. To kick off this series, could you guys just tell us the top 3 differences between litigating in front of the ASBCA and litigating a bid protest in front of the GAO?
Well, I'll go first. I think one of the things, the GAO is much quicker, obviously, than the ASBCA, which can take many years, and the GAO, it's about 100 days. The second thing is that the nature of the discovery and the process is much less formal at the GAO. We do get discovery requests from the other side. We're required to provide the agency report, which is basically the contract file and a few other things. The pleadings are such that we rarely have the opportunity to file like counterclaims like you can at the BCA. You can ask for dismissal of something, although that rarely occurs. And also there are rarely hearings at the GAO. I've been involved with only 1 or 2 in my entire career. So those are some of the differences. Now, Bob has done a lot more BCA litigation than I have, so I'm sure he's got other insights as well.
Yeah, for anybody who wants to be a litigator, you really want to do BCA litigation because it is a lot of fun. It's you're not the punching bag that you are for the GAO. You got to remember that the only real issue is the basis for selection and whether or not you selected the right contract for GAO. And so there's a lot less in the way of documents because there's a lot less history just by the nature, even if it's a large system acquisition. But with regard to BCA, you could be dealing with years of administration issues. It could be more than one issue. It could be the spectrum of complexity could go from being a construction contract, which, trust me, is extremely hard to litigate, in my opinion, harder than some of the system ones that I've had, because you don't necessarily have a litigation support contractor. You're dealing with a very, very limited budget. You can't use expert witnesses as easily. And
we could do a whole episode on the Eichley formula.
Oh, yeah. And you'd be my expert witness on that, Monique. But I mean, I've seen cases go for years and years and numerous interrogatories, they don't adhere to the federal rule with regard to 25. They do. One of the things that's very amusing with regard to BCA is you start out, it's kind of like we're going to play a game and we're going to explain the rules and then we're going to go with them. On complicated cases, they may adhere to most of the rules, but not necessarily all of them. In other cases, it's very loose. Okay, they may adhere to hearsay rule in some cases. In others, it's just like we're a bunch of folks get together and they're purely an equity court trying to provide a remedy. One of the things with GAO in a mini trial that I did is that you may find that the GAO attorney, which is similar to the judge, may be asking what the dialogue was like at a particular time of selection, whereas it may be excluded before a BCA case. Again, the spectrum can go from having interrogatories and putting things together based on the few documents you have, to having a support contractor who provides you with binders based on tags and selection. It's a very, very complicated process. You can file G claims or government claims in a BCA case. You can depose their witnesses, which is a lot of fun. And you can do lots of discovery against them to show that their case has no basis. You have to have adherence to Rule 11 of the federal rules with regard to it being a genuine good faith claim with a reasonable basis, which is kind of nice to remind them of. You can get sanctions. You can get motions to compel with regard to discovery. You do all sorts of briefs, and you do a lot of motion practice, all of which is a lot of fun.
Yeah.
The only issue that I always tell people is you can lose your life in a BCA case because there is no timelines like Michael's GAO cases where you can sit there and say the misery should be over by this point in time. It may never end with a BCA case. Okay, it can just go on and on and on. So that's a big difference in my opinion.
We had, when I was in the Air Force, we had a case going when I was at Wright-Patterson in my first assignment in the early 80s, where the trial team actually filed for a writ of mandamus against the judge because nothing had happened for 4 years. So Bob is correct. These things, you can spend your entire career on one case.
One of the things that really makes you miserable, I did a case in the space shuttle. It was a lot of money, a lot of visibility. And what judges attempt to do is to compel a settlement. They will give you timelines that are virtually impossible. Your life is totally miserable. And your client that you have to work with, their life is going to be miserable. And I can still remember calling up opposing counsel on a break where the judge had issued a timeline and saying, Joey, what are we going to do? We can't adhere to that. We're going to have no life at all. And we went back and both pleaded like we were co-counsel that please give us another couple months to get this discovery in line. Because at the time we were working with like 15 million documents in discovery, and what they wanted was not realistic in our opinion. So it's a different world completely.
So we've got two very different forums for our contract litigation. The GAO has a tight 100-day timeline. Discovery is somewhat limited, and the government's the punching bag. We're defending. We're not doing any offensive plays there. ASBCA, much longer timeline, much more complicated discovery, much more variety of the cases that you might get. And every once in a while, the government can get in a good shot at the contractor there, too.
Oh, yeah.
Well, we are just scratching the surface of this really interesting topic. You guys mind coming back for some more episodes where we can get into the nuts and bolts of the, let's start with GAO cases next time. How's that sound?
We can do
Sounds
that.
good.
All right. Join us again next time between two FARS.